oldest child began living with dad, and then the youngest child eventually came to live with dad.
Was unaware that they were not living with him. They were living with a friend for a year.
Yes, ma'am. They did stay with the friend for a year, but I was still paying child support to Miss Roberts, and I was giving them money.
The issue was that should have been discussed with me as a parent, and the child support is really the biggest issue.
Hey, and did you continue making child support payments after the oldest child moved into your home?
Yes, ma'am.
You're responsible for meeting their daily needs.
Yes, ma'am.
Good morning. Welcome to the 200th District Court. It is Wednesday, June the 10th. We are here in cause number AG-14-000293, Halls versus Roberts. Let's start with appearances for the record, please.
Good morning, Judge. I am Attorney Erin Quander, and I am representing the petitioner and movement, Mr. Stacey Halls.
Okay, you're the attorney?
Yes, Judge.
Okay. This is court, and typically attorneys wear a jacket in court.
I'm so sorry, Judge. I apologize. Let me grab my jacket. I was moving fast. Let me grab it. I apologize.
Okay. And Mr. Halls, you're going to need to take your hat off. Thank you.
My apologies, Judge. I was coming from one court to the next, and I removed my jacket, so I apologize.
That's okay. Thank you. All right. And Ms. Roberts, are you here representing yourself this morning?
Yes, ma'am.
Okay. All right. And Ms. Quander, why don't you, are you representing the movement on the motion, or are you responding to the motion to modify?
I am representing the movement, Mr. Halls, and this is his modification, as well as it's a modification of the underlying SAPSR, as well as a confirmation of arrears.
Okay. All right. And is your announcement still 3 hours, or do you think it's less than that?
I think it may be less than that, but because Ms. Roberts is pro se, I wasn't sure, if the full 3 hours, and I didn't want to underestimate, so I apologize. But I do believe we can get it done in under 3.
Okay. Do you have witnesses other than the parties themselves?
No, Judge.
All right. And Ms. Roberts, do you have any witnesses other than yourself and Mr. Halls?
No, ma'am.
Okay. All right. Ms. Quander, you may proceed with your opening.
Sure. Judge, this is a modification of an underlying SAPSR that was entered on May 28, 2014. And since about 2021, there was a change in circumstance where the oldest child began living with dad, and then the youngest child eventually came to live with dad. And we are here today to ask the court to enter orders that have been consistent with what the parties have been doing, at least for the last 5 or so years. And that really consists of Mr. Halls being appointed as the conservator who has the right to designate where the children reside, with the parties making joint decisions regarding heads, eds, and meds, and Mr. Halls having the exclusive right to enroll the children in school, with Ms. Roberts being granted an SPO, and neither party being ordered to provide child support to the other. And Mr. Halls will carry will carry medical support and dental support for the children. And we're asking for the court to confirm that from the date of the last order until now, that neither party owes any arrearages to the other party.
Okay. All right. And Ms. Roberts, before you give your opening, I'm going to go ahead and swear you in. If you'd raise your right hand, do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. You may tell me what your response is to Mr. Hall's motion to modify.
I don't have any pushback on anything other than there's 2 things. One being that residents of where the kids, I have no issue with them continuing to live with him, but previously, as we discussed, there was a time where he was not able to provide housing, and I was unaware that they were not living with him. They were living with a friend for a year, and that was an issue because they didn't have to. I always had stable everything. At that time, everyone kept it away from me. I was not aware. And that was also at the time where he began to pursue um, the legal side of things, I guess I would say. We'd already had an agreement to drop child support. We went through the courts to do so. That was just after COVID, there was a lot of issues. They told us it was a 6-month thing, and I was hospitalized and then pregnant. So it prolonged that process for me. And then he went this route. But them not having a stable place to live and going from home to home and family to family was not okay with me at all, especially not being aware of that.
Okay. All right.
And then the rear child support, I'm sorry. Can you hear me? There may be a lag because I'm not at home. So there may be a lag. I don't know if you can hear me.
I can hear you. Go
Okay,
ahead.
so I'm sorry. And then the rear child support thing, it was previously discussed whatever the time that he has had them, that he would get credit for that. It was never discussed or agreed upon on my end that it would just wash out whatever he owed, kind of thing.
Okay. I didn't hear that that's what they were asking to do.
Okay, maybe I misunderstood what was happening here. Sorry, again, it goes in and out on my end, and my phone may disconnect. That may be what it is too.
Okay. Ms. Quander, you may proceed.
Sure. Judge, I'm going to call Mr. Stacey Halls as the first witness.
Okay. Mr. Halls, would you raise your right hand and be sworn? Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, go ahead, counsel.
Okay. Mr. Halls, could you please state your name for the record, please?
Stacey Halls.
Okay. And are you the father of Isaiah and Elijah Halls?
Yes, ma'am.
Okay. And how old are those children?
17 and 15.
Okay, 17 and 15. And are you familiar with the prior court order concerning the children that was entered on May 28, 2014?
Yes, ma'am.
Okay, and under that order, Ms. Roberts had the exclusive right to designate the children's primary residence. Is that correct?
Yes.
And under that order, you exercised a standard possession order. Is that correct?
Yes, ma'am.
And also under that order, you were ordered to provide support. Is that correct?
Yes, ma'am.
And you were ordered to pay $428 monthly for the children. Is that correct?
Yes, ma'am.
Okay. And did the children's living arrangements eventually change after that order went into place?
Yes, ma'am, it did.
Okay. And approximately when did your oldest child begin residing primarily with you?
In 2021
Okay.
is when the oldest one moved in with me.
Okay. And after the oldest child moved in with you, did your child support obligation continue?
Yes, ma'am.
Okay. And approximately when did your youngest child begin residing primarily with you?
2022.
Okay. And since that time, have both children primarily resided with you?
Yes, ma'am.
Okay. And have they continuously resided with you since then?
Yes, ma'am.
Okay. And you mentioned that you heard Ms. Roberts mention something about the children, residing with family members. Can you tell the court whether she ever, did anything to initiate the any other type of modifications or relief with the court?
No, ma'am.
Okay. And do you believe at this time that your children are well cared for and that you are stable to provide a residence for them?
Yes, ma'am.
Okay. And since the children have resided with you, have you provided them with housing?
Yes, ma'am.
And since they've resided with you, have you provided them with food and clothing?
Yes, ma'am.
And you've been responsible for their day-to-day care. Is that correct?
Yes, ma'am.
You transport them to school and activities?
Yes, ma'am.
You're responsible for meeting their daily needs.
Yes, ma'am.
And have you maintained health insurance coverage for the children?
I have.
Okay. And since the children have resided with you, can you tell the court what has been Ms. Roberts' visitation with the children?
She sees them whenever she can. There's not a really specific dates whenever she calls to meet up with them or whatnot. It's just whenever she has time.
Okay. And you reside in Austin with the children, is that correct?
Yes, ma'am.
And Ms. Roberts resides in Houston, is that correct?
Yes, ma'am.
Okay. And you would agree that Ms. Roberts sees the kids maybe 2 or 3 times a year? or?
Maybe 4 or 5 or less.
Okay, alrighty. And Judge, do I have permission to publish my screen to show Mr. Halls what has been pre-marked and submitted to the exhibit box as Exhibit P1, which is his child support payment record?
You may.
Okay, thank you. Okay, and Mr. Halls, are you able to see my screen okay?
Yes, ma'am.
Okay. Alrighty, and I'm showing you what's been pre-marked as Petitioner's Exhibit P1. You recognize this document?
Yes, ma'am.
Okay, and what is this document?
My payments, my child support payments.
Okay, and does it fairly and accurately reflect the child support payments made to you?
Repeat it one more time, please.
Does it fairly and accurately reflect the child support payments that you made for your children?
Yes, ma'am.
Okay, and has this document been altered in any type of way?
No, ma'am.
Okay, Judge, I would like to go ahead and admit Petitioner's Exhibit 1 into evidence.
Any objection?
No, ma'am.
It's admitted.
Okay, and under the court order, Mr. Halls, you were ordered to pay $428 monthly for the children. Is that correct?
Yes, ma'am.
Okay, and did you continue making child support payments after the oldest child moved into your home?
Yes, ma'am.
Did you continue making child support payments after the youngest child moved into your home?
Yes, ma'am.
Okay, and if we look at the payment record, we can see that you made, payments up until 2022, 2023. And while you were making those payments, you would agree that both children were residing with you.
Yes, ma'am.
Okay, and were you also continuing to financially support the children while they were living in the home with you?
Yes, ma'am.
Okay, and during the time when in 2021, when the first child came to live with you and you had one child living with you and Miss Roberts had the other child living with you, was there ever any exchange of financial support from, Miss Roberts to you?
No, ma'am.
Okay, and when the second child came to live with you, did Miss Roberts ever provide any financial support to you?
No, ma'am.
Okay. And in December of 2025, when we came to court, you and Miss Roberts entered into some agreed temporary orders. Is that correct?
Yes, ma'am.
Okay. And under those temporary orders, were you designated as the parent with the exclusive right to designate where the children reside?
Yes, ma'am.
Okay. And with those temporary orders, Miss Roberts was awarded a standard possession order. Is that correct?
Yes, ma'am.
Okay, and under those temporary orders, were either of you ordered to pay child support to the other?
No, ma'am.
Okay, and have you complied with those temporary orders?
Yes, ma'am.
And do you believe that the children are doing well under those temporary orders?
Yes, ma'am.
Okay, and are the children you requested or you stated that the kids have been residing with you. Is it your request today for the court to continue the arrangement reflected in the temporary orders, agreed temporary orders?
Yes, ma'am.
Okay, and are you asking that you remain the parent with the exclusive right to designate the children's primary residence?
Yes, ma'am.
Okay, and are you asking that Ms. Roberts continue to exercise a standard possession order?
Yes, ma'am.
And are you asking that neither party be ordered to pay child support to the other party?
Yes, ma'am.
Okay, and are you asking to continue to provide the health insurance for the children?
Yes, ma'am.
Okay, and at this time, are you seeking any retroactive support from the time that the children were residing with you?
No, ma'am.
Okay, and you understand that you have the option to ask for retroactive support from the time that the children have been residing with you?
Yes, ma'am.
Okay, and are you asking the court to confirm that from the date of the initial court order that was entered in May of 2024, May of 2014 until now, that you don't owe any arrearages to Ms. Roberts and that she doesn't owe any arrearages to you.
Yes, ma'am.
Okay, and do you believe that that is, fair and equitable, considering that, the children still have remaining years until they turn 18 and you're not seeking any support?
Yes, ma'am.
Okay, and you think that that's fair and equitable, considering that, you've continued to pay for your child support beyond when both children were living with you?
Repeat it one more time.
And you believe that that's fair and equitable, considering the fact that you continue to make support payments even when the children came to live with you?
No.
Okay, let me re-ask the question. You believe that, it's because you continue to pay your child support, after both children came to live with you, do you believe it's fair, for that to be taken into consideration in your arrears?
Yes, ma'am.
Okay, and are you asking the court to take into consideration that, Ms. Roberts, otherwise, was not paying any support to you while the children have been living with you for the past 4 years, that, it's fair for it to kind of be a wash?
Yes, ma'am.
Okay, and I'm going to show you, Judge, if I have permission to share my screen and show Mr. Halls what's been pre-marked as Exhibit P-2.
That's fine. You may share screen.
Sure. Okay. Mr. Halls, are you able to see my screen at this time?
Yes, ma'am.
Okay. And do you recognize this document?
Yes, ma'am.
Okay. Is this the summary of requested relief that you are asking the court to grant you today?
Yes, ma'am.
Do you believe that it fairly and accurately summarizes what you are seeking in your requested relief today?
Yes, ma'am.
Okay. And is there any reason, or I'm sorry, Judge, I would like to go ahead and admit what's been pre-marked as Exhibit P-2 into evidence.
Any objection?
No, ma'am.
P2 is admitted.
Okay. And are you asking for the court to terminate your child support obligation?
Yes, ma'am.
Okay. And is there any reason why the court should not continue the arrangement that has been in place under the agreed temporary orders between you and Ms. Roberts?
No, ma'am.
Okay. This is all that I have for this witness, Judge. Or I'm sorry, one last question. Mr. Halls, do you believe that what you are requesting today is in your children's best interest?
Yes, ma'am.
Okay. I have nothing further for this witness, Judge.
Okay, you passed the witness.
Yes.
You may pull down the screen share, please.
Okay, I'm sorry.
All right. Ms. Roberts, do you have any questions for Mr. Halls?
Yes, ma'am, I do.
Go ahead.
Do I address him as Mr. Halls? Is that what? I'm
Yeah.
sorry. Okay. Let me. Mr. Hawes, you stated that the kids did live with you the entire time. In the school year, during the school year of 2022, I would say to 2023, did they not live with your friends?
Your Honor, I'm going to object to relevance. One, Ms. Roberts has no affirmative pleadings on file requesting any relief, and it is 2026. These kids have resided with Mr. Halls consistently, and I'm not sure what,
Again, Judge, my concern is that the kids were living elsewhere without my knowledge. No one informed me that he did not have proper housing. He was not able to at the time. Since then, yes, he has, but it goes to the relevance of the case. During that time, I was not aware where they were, what was going on, and I would ask the kids, hey, why are you at your friend? Oh, we're just spending the night, because their dad did not want me to know of fear of me doing that. When I was made aware, I did make arrangements with him. I contacted him. We discussed it, and he asked me to give him 6 months to find proper housing, which I did. And since then, he has had proper housing. However, the concern is we have one graduating next year and one still in school. The effects of living with the friends affected the youngest one. That's my concern. He is a very emotional child and may not always discuss certain concerns with his dad, not of fear, not out of any of those things, just because he's a child and that's just what he does. It's how he copes. I'm not saying he's a bad person, but my concern is very valid.
Okay. The objection is overruled. Mr. Halls, and you may answer the question.
Yes, ma'am. They did stay with the friend for a year, but I was still paying child support to Miss Roberts, and I was giving them money to provide food for them as well when they were staying over there.
Okay.
And
Ms.
during the-
Roberts, you can go on.
Yes, ma'am. During that time that you were also providing for them, did I myself also provide for them as well during the time that you've had them, whether that be school clothes, school shopping, school needs, fees, and those benefits, those things along those lines? Did I not also do those things?
You gave them money, but you didn't give me anything. So
No, I did not. I'm not, that's not, sorry. I should ask the question. I have not ever put money in your hands for them. No, I have not. That's not the question. But specifically to the kids, have I not provided for them financially, emotionally, and those things that they needed during that time and throughout the entire time that they've been with you?
Yes.
Okay. You mentioned earlier that I've only seen them 5 times a year. I've been to multiple football games, plays, and different things where I drive after work to Austin and back home to those things. Is that not accurate?
Yes.
Does my mom not pick them up and bring them to me to family events to see them as well? Is that not accurate?
Yes.
So it's also true. It's also true to say that I have seen them more than 5 times throughout the year in the time that they've been with you, correct?
I'm
Well,
going to object, Your Honor, to the relevance of the question at this time, Mr.
The
Halls.
relevance of the question is that it's being painted as if I'm not active, or being painted as if I'm not an active parent or financially taking care of my kids, and that's inaccurate. So I have the right to ask him these questions so that they have the full picture.
Okay. All right. I just need to make it very clear that I need one person to speak at a time. So if y'all would try not to interrupt each other. The objection is overruled. You may answer the question. It might need to be misstated.
Yes, ma'am. Yes, ma'am. During the time that you've had the kids in total, from let's just start the conversation over so we have a clear picture here. In 2021, when you took one child and I took the other, Mr. Halls, you cared for one child and I cared for the other child while you still paid child support. Is that accurate? That's a true statement?
Yes, ma'am.
Okay. Once both children began to live with you, that was decided once I decided to move to Houston, correct?
Yes.
And although you continued to pay child support during that time, you and I had multiple conversations about ending the child support, going through the process, and how whatever you were paying during the time that they were there, we were okay with that going toward the kids and things of that nature. Is that not okay? Is that not correct?
Yeah.
Okay. Up until the point where I was in the hospital and experiencing pregnancy, we had no issues with how we were previously going about this, which would, hey, whatever you've been paying, whatever you've paid, it'll be credited toward what you owe, correct?
Yes.
Okay. As far as the children having medical benefits, their entire life up until 6 months ago, who has provided that coverage?
You have, because that was what the court ordered.
Okay, fully provided that coverage. I have, right? That means doctor's appointments, things of that nature.
Yes, but not all the time did they have coverage. It was off and on.
Yes, in between jobs. Whenever I lost a job, that is correct. They did not have coverage, but it was consistent. It wasn't months or years or things of that nature, correct?
Yes, until maybe
this past year.
Yes.
Yeah, this past year, I lost my job and I was out of a job for 1.5 years during this court process. That is correct. Okay. Outside of that, financially to this day, do I not provide and support my kids as much as I'm aware of? Let's say that.
I can't really say because they don't tell me when you give them money or what you do if you send them money. They don't tell me, so I'm not really sure.
That's a fair statement. You and I do not communicate outside of me communicating with them and then them communicating with you. That is accurate. Are you aware that in the past year, this past school year, our youngest son has went from a straight A student to a C student?
Yes.
Okay. Because when were you made aware of that?
When I've been watching his grades because he tells me his reports.
Okay.
And when you had a conversation with him?
After I had a conversation with him, and he'd already been failing. He'd already been failing for 6 weeks at that time. Okay.
He failed one time.
Yeah, for 6 weeks at that time.
For 6 weeks, yes.
Did he explain to you why?
No.
Okay. Outside of the financial part of this, the money part of this, that you and I, that's the only disagreement that I've ever had regarding raising the children
Yes.
and the housing situation, which we resolved, correct? Where
Yes.
do you understand the concern of them living with someone outside of me or you that I am not, me not being aware of that?
Oh, you knew about it. I told you about it. You just didn't. We had plenty of conversations about it, and you did give me time to get a place.
When I was aware, we had a conversation about it, correct?
But you knew about it maybe 3 months in, 4 months in after they moved in.
But again, it was after it happened, right?
Yes.
Okay, there was no conversation with me prior to that happening so that we could make arrangements as parents. It was just a decision made and then I came in afterwards.
Yeah, but we also talked about the reason why the boys didn't want to move with you to Houston. They wanted to stay down here with me and they Mimo.
Yes, so it wasn't me abandoning my responsibilities. It was me saying they didn't. No, it was them wanting to stay there, correct?
Yes.
That's why they're with you.
Yes.
Okay. That's all I have, Judge.
Okay. Ms. Quander, anything else for this witness?
I don't have any questions for this witness, Judge.
Okay. Mr. Halls, I do need to ask you a few things because it sounds like the request is for the court to enter an order that neither party pay child support. And the court is always looking to the best interest of the children. And so I'm going to need some information from you about income so that I can have an idea that when the child is in your home or when the child is in Ms. Roberts' home, that they're both provided for. Does that make sense to you?
Yes, ma'am.
Okay. Can you tell me what kind of job you have?
I work at a carpet cleaning company.
Okay. And do you have a hourly wage or salary?
I make $27 an hour.
Okay. And do you work 40 hours a week?
Yes, ma'am.
And so you're working a full-time job?
Yes, ma'am.
Okay. And do you know what your take-home pay is a week or a month?
It's about 2,000 a week. Every 2 weeks is 2,040.
Okay.
Okay. I mean, we talk about it more.
Okay. And so with the income that you earn, you have your two kids living with you. Is anyone else living with you?
No, ma'am.
Okay. And with the income that you earn, are you able to provide housing, food, clothing, the things that the kids need?
Yes, ma'am.
Okay. And do you know what income Ms. Roberts makes?
No, ma'am.
Okay. And does she have other kids or dependents that she supports?
She has a little daughter. Yes, ma'am.
Okay. All right. Do you think that it's in the best interest of your children that neither party pay child support in this case?
Yes, ma'am.
Okay.
I think it's fair.
You do. Okay. All right. That's all I needed to know. Ms. Quander, do you have any other witnesses to call?
I would like to call Ms. Roberts, Judge.
Okay. Go ahead.
Okay. Ms. Roberts, you currently reside in Houston, Texas. Is that correct?
Yes, ma'am.
And you would agree that even though you do have the option to exercise the first, third, and fifth weekend with your children, that you don't exercise every single first, third, and fifth weekend with your children. Is that correct?
Often they are not available. That's why my oldest son is in a lot of activities.
Non-responsive. You would agree that you don't exercise every first, third, and fifth weekend. Is that correct, ma'am?
Again, my son has multiple activities and they're not available on those days. So if that's my visitation, they have to be available. And if they're not available for me to get them, I cannot. And that's per their dad. He usually tells me my dad said I can't, or my dad says I have football or this.
Okay. So to answer the question, you don't see them every first, third, and fifth.
I do not see them because they're unavailable. That's my answer.
Okay.
And we work around the schedule. It may not be the first and the fifth. It may be other days that they're available. So we depending on when they're available, yes.
Okay, and you previously testified in regards to a 2022 incident where you said the children were residing with someone else. Is that correct?
Correct.
Okay, and
I believe it was I can't say when they moved exactly, but it kind of happened between the end of 2022, beginning of 2023.
okay, and whatever family member you're referring to,
It was not a family member.
oh, but it was someone that the children had a relationship with and were familiar with. Is that correct?
Only one child was familiar. He's best friend.
Okay, and you would agree, ma'am, that if you were visiting with your children regularly during that time, you would have likely known what their living situation is?
Again, when I tried to pick them up, it was not allowed because it was unavailable. Oh, my dad has plans. If I was aware that they were living with someone else or he was experiencing
Objection
that, I would have done it.
non-responsive, Judge.
Sustain. Just answer the question. You'll have an opportunity.
No,
Robert.
no. I'm sorry. Are you? It's lagging on my end, so I hear things at the end.
I just need you to answer her questions as she asks them. You will also have an opportunity to tell the court whatever information and testimony you want to give to me. But while she's asking questions, just answer them.
Okay, got it. Yes, ma'am.
Okay. And Ms. Roberts, you would agree that from the time that the children began living with Mr. Halls, either when the oldest was there or when, both children were there, that at no time during the time when the children have been in Mr. Hall's possession or anyone else's possession, that you have not brought it to this court's attention that your children were not being well cared for, or that there was any issues?
Are you asking me, did I not bring it to the court's attention?
Did you file any?
No, I have not filed. No.
Okay, thank you. And Ms. Roberts, you were served with discovery on April 6, 2026 in this case. Is that correct?
When you say served, are you asking someone had me papers or something? I have not been home in Texas since March 10th.
Yes, ma'am. Through your email address that is on file with the court, the Keisha Roberts address, you would agree that you were served on April 6, 2026 with requests for production, interrogatories, and requests for disclosures?
Not that I'm aware of. No, ma'am.
Okay. But that is your correct email is Keisha?
No, ma'am. My name is Keisha Roberts at gmail.com.
Okay, and so it's possible that you could have been just not opening your emails. Is that correct?
No, I get email alerts. That's why I saw your email yesterday. So if it didn't come from you or the court exactly, I'm not sure how it would come, but no, ma'am, I'm not aware of anything other than the email I received from you yesterday, CCing the court, and from the previous court's, I think it's his bailiff or his court reporter.
Sure. Okay. Alrighty. And at this time, ma'am, you're not asking the court to designate or to continue to allow you to have the exclusive right for the children to reside with you. Is that correct?
That was never my request. No, ma'am.
Okay. And you are in agreement with Mr. Halls, remaining as the primary conservator. Is that correct?
I have no concerns with how he parents or any of those things. No concerns.
Okay. And you are okay with having a standard possession order for visitation with your kids. Is that correct?
We have no issues there.
Okay, and you are correct. You are okay with you and Mr. Roberts. I'm sorry, you and Mr. Halls making joint decision making as it pertains to the children. Is that correct?
Yes, ma'am.
Okay, and you'd be okay with Mr. Halls having the independent right to apply for the children's passports and for you to be able to do the same as well?
I don't think I heard your whole question. Did you ask about passports?
Yes, ma'am.
I don't think they have passports. I don't know if I heard you all the way. I don't think they have passports.
Okay, but you would be okay if you or Mr. Halls could apply for them a passport. Is that correct?
Yes, ma'am. I don't have any disagreements.
Sure. Alrighty. And Ms. Roberts, what is your current income?
$18 an hour, $1,300 every 2 weeks bring home after taxes. And I occasionally do freelance work, and that's usually like private pay, and it varies based on the clients, like what their needs are, hours, things like that.
Sure. Okay. And you understand that Mr. Halls is not asking you to provide any, support for the children. Is that correct?
Yes, ma'am. I understand that.
Okay. But you do understand.
I couldn't hear that last part. I couldn't hear you.
Okay, and I was just going to ask you, you also understand that he could ask, the court to order you to pay child support, but he's not doing so at this time.
I understand. Yes, ma'am.
Okay, and okay, I don't think I have. Oh, there's one other question, Ms. Roberts. You don't have any pleadings on file seeking any relief from the court today, is that correct?
I don't think I understand what that means. I'm not sure.
You have not filed any petitions or motions that are before the court in this matter, is that correct?
No, ma'am.
Okay, and I have no further questions for this witness, Your Honor.
Okay. All right, Ms. Roberts, so now Ms. Quander has called her witnesses, her client, and you, and now you have an opportunity to call any witnesses that you would like to, including if you would like to call yourself and just testify in the narrative form, telling the court what your requests are in relation to this motion to modify.
Yes, ma'am. I don't have any witnesses. I think because the issue for me was just the fact that I wasn't aware prior to the kids going to stay with Stacey's or Mr. Halls's friends, that I want to make sure that I didn't have an issue that these are the people that he chose for them to stay with. The issue was that should have been discussed with me as a parent, and we should have made arrangements. This is not family. These are my oldest child's best friends and his parents. Are they good people? Absolutely. I'm not saying they're horrible people. I am not friends with these people. I do not have a relationship. I don't know anything about these people. As a parent, that should have been discussed. My mother is familiar with these people through I don't know if everyone here is aware of trail riding groups. That's the relationship prior to this. He and I had a conversation, as I discussed after the fact, because I have no ill will toward him or the situation. I allowed him that time after we had a conversation to find a place and provide stability, which he's done so. So I'm not harping on the issue that he did it. I don't want us to harp on that. The issue is that it should be a communication thing between the two of him as to this is what's happening in my life right now. I need time to figure it out. I have the ability to move back to Austin at any time. I have a place where I can stay. I have a place where the kids can stay and provide that for them if he's not able to. That's all. That's the only reason I brought that up. Not to say that he did something horrible or he made a bad decision or he wasn't being responsible. And also the biggest issue that we both have here today is the rear child support. Prior to 2021, as those records that Ms. Quander submitted, he was not paying. He paid sporadically. He was not regularly visiting. He was not doing those things, and he can testify and agree to that, which is why we agreed that anything that he paid after, which is when he started to pay, would go back to his rearage. As he already testified, he agreed upon that. He agreed to that, as he just testified. We have no other quorums, no other issues. I don't have no parenting issues with him. I don't feel that they're at risk or safety. That's clear. I continue to take care of my kids with or without child support. He will continue to do the same because we both care for our kids. When we have disagreements, we work through it with our kids. If we can communicate, we communicate. The child support is really the biggest issue. If he decides to put me on child support, that's just what it is. I'm going to continue to take care of my kids.
Okay. So and let me just get some clarification. Going forward, Ms. Roberts, you are asking that if Mr. Halls and the children move residences or lose housing, that you be notified of that.
Correct. That's all I'm asking. Yes, ma'am.
Okay. And let me ask you, well, I think she covered the income information, but I just want to confirm with you, you feel that Mr. Halls is able to provide for the children while they're in his care. You're able to provide for the children while they're in your care, and you believe it's in the best interest that the court not award or not order either party to pay the other child support, given your income and financial ability to support them.
I feel, yes, ma'am, I do agree with what you're saying. And I think that prior, the issue was that, of course, we were young. So him kind of figuring out financially what he has going on, we both find ways to take care of our kids if we have to pick up other jobs or whatever. So I don't find any issues with those things at all.
Okay. right. Ms. Quander, any other questions for Ms. Roberts?
No other questions, Judge.
Okay. All right. And do you wish, I guess, Ms. Quander, it sounds like to me that the parties are actually in agreement on many of the items that are in your client's modification. And the only additional thing that Ms. Roberts is asking is that before Mr. Halls moves either himself and the children or the children, that she be notified of that. And I think that's a reasonable request. So there may be some common ground here, but let me know what your thoughts are on it.
Oh, absolutely, Judge. And he has, maintained the same residence, from, I guess, the last couple of years. And that is correct, Judge. It seems like they are in agreement with a lot of things, and Mr. Halls doesn't have any issue with, communicating and letting her know where he resides with the children.
Okay. And you're asking that the child support be, the obligation be terminated moving forward. The Attorney General isn't here, so I'm not sure if you have a request on arrears or if what your request was on that.
I do, Judge. I have a motion to confirm the child support arrearages, and we're asking the court to take into consideration that, there could have been a potential for Ms. Roberts to pay for, these children moving forward, but, both parties are in agreement that that's in the children's best interest that neither pay for right now. And we're asking the court to take into consideration, based on the payment record, that Mr. Halls has paid for support for the children, and even after the kids were living with him, and that we believe that, it's in the best interest of the children that neither party owe arrearages, to the other from now until, I guess from the date of the last order until today. And Ms. Roberts has also not presented anything in regards to payments, that she's, made or paid, and we feel like that's fair for there to be no arrearages in the case.
Okay. Well, what is the actual evidence in front of the court that there are no arrearages? I feel very uncomfortable given that the Attorney General is not here at this hearing, and that is normally something that the Attorney General would weigh in on one way or the other.
Sure, Judge. And I actually do not remember the name of the gentleman that I spoke to that is the representative for the Attorney General, but he told me that this was not a case that the Attorney General is monitoring or involved in. I can try to let you know his name. When we were before the last judge, they asked me to reach out to him, and I did. And let me see if I can. Oh, his name is Charles. No, hold on. I'm sorry, Judge. I don't want to hold the case up. Oh, his name is Daniel Nielsen, and he told me that it's not a full service OAG case and that the case is registry only. So it says that he responded in the email that they don't track arrears balances and that they could only provide a record of payments, and that's it. But that's who I spoke with for the representative for the OAG, and they were noticed for this hearing as well.
We did submit documents to have the child support dropped in, I don't know, Mr. Halls can probably confirm, it was probably 2023 December, and no one showed up for our call while we were on the call, and we worked with them for about, I don't know, 3 to 6 months trying to have it resolved. And at that time, they did have a rearage that it showed on the site. And I don't remember the number. I don't know if he remembers the number exactly. At that time, they did. But that may be why, again, they're not able to provide his attorney with any information, because we had actually tried to have it dropped in 2022, 2023.
Okay. Ms. Quander, so I'm going to give you an opportunity to reach out to counsel for the Attorney General's office and see whether this is something that they would agree to or not. I don't know that there's evidence in front of the court that there are no arrears. I mean, you had an exhibit and I think it was just a payment history. That's not enough to let me confirm or zero out or evaluate arrears one way or the other.
Sure. I guess, Judge, I'm happy to, reach out to him, but that is, what I asked and I don't know if the court wants to see this email or see if I can get Mr. Nielsen on the call, but I specifically said to him, are you able to assist me with the FINA report for the above referenced case? And I said, I've only been able to receive a payment record. I'm trying to see how much arrears are owed by Mr. Halls. And that's what he responded and said, it doesn't appear that either parent has an open full service case with the OAG, and their case is currently registry only. He said we don't track arrears balances. We can only provide a record of payments that have passed through the state disbursement unit. And that's, pretty much what he said. I'm happy to try to reach out to him again.
Okay. I think that would be helpful. I mean, I'm just not in a position where I can say there are no arrears without documentation that that's the fact, or without an agreement by the Attorney General to, one way or the other on this.
Okay.
Typically, there is an Attorney General who's present. I mean, this is an Attorney General cause number. I don't know. I'll let you have some time to reach out to them.
Sure.
In the meantime, unless there's something else that we need to discuss, I'm ready to go ahead and provide the parties with rulings on the motion to modify.
Okay. Sure, Judge. I'm fine with that, and I am sending over the email to him now.
Great, thank you. Okay, so Mr. Halls filed a modification here, and that modification is granted. Mr. Halls will be designated as the primary for determination of the children's residence. The parents will remain, of course, joint managing conservators with joint decision making. Going forward, Mr. Halls' child support obligation is terminated. He can apply for and hold the children's passports. And Ms. Quander, if you would incorporate the Texas Family Practice Manual language on passport and travel notice, it has some very standard language about how the parties are to notify each other if they are traveling internationally with the kids. And also, Mr. Hawes will be required to notify Ms. Roberts about any change in the residence of the children. And I think that covers it, but let me know if I missed anything.
Okay. I believe that's it as well, Judge. And then I can let you know, or do you want us to just hang on to Mr. Nelson maybe responds, or?
I would go ahead and ask that you prepare an order on the modification. And as it stands, I don't believe that I can make any ruling on arrears one way or the other, in the absence of the Attorney General weighing in on that one way or the other. If they can confirm there are no arrears and that information is agreed to and shared with the parties, then you could include it in the final order. But I'm not comfortable doing that without confirmation from that office.
Okay, and then Judge, if we don't get the confirmation from them, then what can we do then? Because my petition for the confirmation of the arrears is, actually before the court, and they have been notified, the Attorney General, of the suit in this hearing.
I mean, well, I think it's relief that was requested, but it's going to be denied because I don't have any evidence of, you don't have evidence of what the arrears are or not. So
Okay.
I don't think I'm able to grant that particular relief.
Okay. I guess, Judge, would it be too late for me to also, I guess, my point with the not doing the calculations for it was so because I do believe Mr. Halls had provided evidence that, there was instances where, he had the kids where mom had, one child, and arguably the court could have taken into consideration what, she could have owed and what he could have owed. And that was my, reason for not doing the calculations on the numbers, specifically. And as well as in the last hearing, the judge that we were before, he mentioned in the temporary orders that, the court could also take into consideration that because Ms. Roberts is not ordered to provide any support going forward, but she otherwise could have been ordered to, that, the court could take that into consideration into any, balance or anything as well. But I'm, happy to go through the numbers if that, is something that the court is requesting. And that was my whole point of also asking, about, I did serve Ms. Roberts with discovery to see, what her income would have been from the time period that we filed this modification suit. And, Mr. Halls would have had the option to, do any offsets, but the discovery wasn't responded to. And that's why, the relief that we're requesting is what it is.
Okay, so I mean, you're asking me to do something and you've provided no evidence that would allow me to make the decision that you're asking for. So
Sure.
I can't give you legal advice, but we're here. This is the hearing. I've made my rulings. The parties are free to confer and agree on something outside of the courtroom. I cannot do anything with an arrearage because I don't know what the arrearage is. I mean, you haven't brought that evidence to court today. So I don't, whether the fact that mom might have paid child support, I mean, that's a hypothetical, that's not a part of your motion. And I'm having a hard time kind of following the logic here. I mean, you're wanting me to do something and you don't have evidence of it.
Okay. Already, Judge. Well, then I would, I guess, respectfully ask that I don't know when I will be able to let you know that Mr. Nelson is going to respond, or how do you want me to let you know? Or are you just saying-
Contact my staff?
Sure. Okay. Alrighty. Well, then I will do that, Judge. And then is the date for me to submit the modified order, is it going to be today? You want me to submit it today?
No, I can give you some time. Let me pull up my calendar here. You can submit it by June 18th. That gives you a little over a week.
Okay. Alrighty, Judge. And I will go ahead and get that order on file, and I'll provide it to Ms. Roberts for her signature as well.
Okay, yes, circulate the order to Ms. Roberts for review and approval as to form, and then it can be emailed to Ms. Seeger. She provided the Zoom link, so you have her email. And I think that should take care of it.
Okay, thank you, Judge. May we be excused?
Yes, you're all excused from the courtroom.